Massie put 3 documents on the screen. A Republican cornered his own party's AG. He was not a Democrat. That is the first thing the hearing room understood when Thomas Massie, Republican congressman from Kentucky, stood up on February 12, 2026, and told the House Judiciary Committee he had 3 documents from the DOJ's own production, not from a Democratic opposition research file, not from a hostile press outlet, from the Department of Justice itself. The documents that the Attorney General's own department had produced under the requirements of the Epstein Files Transparency Act. The documents that Pam Bondi's own DOJ had processed, handled, and released. Massie was not going to make speeches. He was going to put things on the screen. The first document went up. This channel tracks the documentation as it moves through the legal system. If you want to follow where this goes, subscribe and turn on notifications. New videos drop when the record produces something worth documenting. Let's start with why the partisan identity matters. Because the hearing room understood it immediately and the coverage has not fully processed it. Massie is a Republican. Bondi is a Republican. The Trump administration that Bondi served is a Republican administration. The Epstein Files Transparency Act that Bondi's DOJ was implementing was signed by a Republican president. And on February 12, 2026, a Republican congressman from a safe Republican district stood up and used the DOJ's own documents to demonstrate that the DOJ had inverted the single most basic requirement of the law it was supposed to be implementing. This is not a partisan attack. This is an intra-party accountability moment. It is the specific kind of accountability that is most damaging to an institution because it cannot be deflected as partisan opposition. The standard response to a Democratic member's questions about the Epstein Files has been to invoke the prior administration. The Biden DOJ, Merrick Garland, years of inaction by the other party. That deflection requires a partisan frame to work. It requires the questioner to be positioned as an opponent whose inquiry is politically motivated. Massie removed that frame entirely. He was not opposing the administration. He was a member of the same coalition, asking about documents the administration's own department had produced in a hearing room where the majority that controls the committee is also from his party. When the response came, failed politician, hypocrite, it landed in a different context than the same response would have from a Democratic member's question. Bondi was attacking an ally. The room registered that. The Epstein Files Transparency Act had one core requirement. 1. Release the names of perpetrators. Protect the names of victims. The law's logic was straightforward. The people who abused and trafficked Jeffrey Epstein's victims should be identified. The people who were abused and trafficked should be protected. The perpetrators face legal and reputational consequences. The survivors retain privacy. The law was designed with that specific moral architecture, accountability for the powerful, protection for the vulnerable. And it required only that the DOJ implement that architecture in its disclosure process. The DOJ inverted it systematically and documentably. Victim names were released. Perpetrator names were redacted. Survivor photographs, nude images of victims, were published in the DOJ's portal, covered in a New York Times article that Massie submitted to the record. Co-conspirator names were in fully redacted documents that congressional pressure was required to unseal. FBI interview forms in which survivors named the men who abused them are layered with redactions and, in some cases, removed from the portal entirely. That inversion is not a clerical error describable as a low error rate. It is a documented directional failure, a system that makes consistent errors in one direction. Protecting the powerful, exposing the vulnerable, is not a malfunctioning system. It is a system functioning as it was designed to function. Massie's 3 documents were not random samples from a production that contained mixed results. They were exhibits demonstrating the specific, consistent direction of the errors. He had 3 exhibits. Document 1. An email from victims' lawyers to the DOJ. A list, not a general communication about the file release process. A specific list of names, the names of their clients, the survivors they represented, with a specific instruction. Do not release these names. The DOJ received the email. They processed it. We know they processed it because of what they did with it. And this is the specific evidentiary detail that transforms the publication from negligence into something that requires a different explanation. They redacted the lawyer's name. The person who sent the email, the attorney who had written to the DOJ on behalf of her clients with a specific request about their privacy, had her own name removed from the document before it was published. The DOJ identified the sender and decided to protect that person's identity. And then they published the survivors' names anyway. The exact names the email had been sent to protect. The names on the list of names not to release. 2 redactions happened in the processing of that email. 1 protected the lawyer. 1 should have protected the clients. The first redaction was made. The second was not. And the email that was supposed to prevent the survivors from being identified was published as a guide to identifying them. Massie stated this in the hearing room with the document on the screen behind him. They received it. They touched it. They knew. We know they knew because they redacted the lawyer's name. They protected the person who sent the warning while ignoring the warning itself. The survivors whose lawyers had specifically contacted the DOJ to protect their privacy received phone calls after their names appeared in the public release. Many of them had not wanted to be known. They had lawyers specifically because they wanted to manage their exposure. The DOJ had been contacted. The DOJ had confirmed receipt by redacting the sender, and the names went out anyway. Massie said they had a list of people not to expose. They exposed them. That sentence is not analysis. It is a description of what the document on the screen showed. Document 2. The first document showed the DOJ ignoring a warning. Now the second showed what the DOJ was hiding. A document titled Child Sex Trafficking Co-Conspirators, fully redacted in the public release. The title was visible. The content was black. Massie said he was going to unredact it in the hearing room. He did. Les Wexner's name was in the document. Not in a financial context, not in a tangential reference. In a document titled Child Sex Trafficking Co-Conspirators, as a co-conspirator in child sex trafficking. Let's be precise about who Les Wexner is, because the name requires context that the hearing room did not stop to provide. Wexner is a billionaire retail executive, the founder of a company that became one of the largest clothing retailers in the United States. His name was known in the Epstein context before this hearing. He was not a new discovery in the file release. He was a documented feature of Epstein's documented world. The specific nature of the relationship matters. Epstein did not merely know Wexner or socialize with him. Epstein managed Wexner's finances. He was given power of attorney over Wexner's affairs, a legal instrument that grants the holder authority to make binding decisions on behalf of the grantor. Power of attorney is one of the most consequential legal relationships one person can grant another. It means Epstein had the legal authority to act in Wexner's name in financial and other matters. That level of access, granted voluntarily, is the kind of relationship that federal investigators examining the Epstein operation would be expected to examine closely. Wexner's name appears more than 4,000 times in the Epstein files. That number represents a density of documented association. Not casual social contact, but recurring specific documented appearances across thousands of separate files in a federal sex trafficking investigation. Bondi's own deputy had acknowledged to Congress that Wexner appears hundreds of times in the released documentation. That acknowledgement was accurate as far as it went. What it omitted was the specific document, the co-conspirator list, where the nature of the documented association is not financial management, but child sex trafficking. What the deputy had not mentioned was this specific document, the one titled Child Sex Trafficking Co-Conspirators, the one where Wexner is listed not as a financial associate, not as a frequent contact, but as a co-conspirator in child sex trafficking. That document had been fully redacted in the public release until Massie took it into the hearing room and put the unredacted version on the screen. Bondi said his name had been corrected within 40 minutes. Massie said, within 40 minutes of me catching you red-handed. That exchange is the document. The DOJ's framing is correction. A processing error identified and fixed in a reasonable time frame. Bondi said 40 minutes as if that number represents institutional responsiveness. Massie treated 40 minutes as a measure of something else entirely, the interval between his public disclosure and the DOJ's response to it. If Wexner's omission from the co-conspirator list was a genuine processing error that quality control would have eventually caught, the correction timeline would exist independently of what Massie did in the hearing room. The correction would have a paper trail showing when it was identified, who identified it, and what process produced it. What the record shows is that the correction happened 40 minutes after Massie displayed the unredacted document in a congressional hearing on national television. That timing is not evidence of a functioning quality control system. It is evidence that the redaction was removed after a member of Congress forced its public disclosure. Those two things, an internal correction and a response to external pressure, produce the same output but mean entirely different things about what the original decision represented. Document 3, the email, survivor names published, perpetrator names protected. The co-conspirator list, Wexner's name redacted until forced. Now the witness interviews, FD302 forms. The FD302 is the FBI's standard form for documenting witness interviews. When an FBI agent interviews a witness, the substance of that interview is recorded on an FD302. It becomes part of the investigative record. The form captures what the witness said, how they said it, what specific details they provided. In a sex trafficking investigation, an F, D302, from a survivor is the closest thing that exists to the survivor's own account in the evidentiary record. In the Epstein investigation, survivors gave testimony to FBI agents about who was involved, who was present, who participated, who was named by the people who lived through the trafficking operation. Those accounts, recorded on FD302, forms by the agents who conducted the interviews, are the primary evidentiary documentation of survivor experience. They are not duplicated in other parts of the record. They are not summarized elsewhere in a form that preserves the specificity of what each survivor said. If those forms are redacted or removed, the survivor's account, the specific words, the specific names, the specific circumstances they described to federal investigators, becomes inaccessible. Massie described what happens when you try to access the Epstein FD302 forms through the DOJ's portal. You find a redaction. You click through to see what is behind the redaction, another redaction. The underlying content is not available. And then some of the files have been pulled from the website entirely, not redacted, removed. They cannot be searched. They cannot be found through the portal. The accounts survivors gave to FBI investigators about who was involved in the trafficking operation they survived are, in some cases, gone. He asked Bondi, who made these decisions? Who in your organization made the determination to redact the survivors' names while protecting the perpetrators? Who made the determination to redact Les Wexner's name as a co-conspirator in a document titled Child Sex Trafficking Co-Conspirators? Do you have that kind of accountability in your department? The question of who is not rhetorical. It is an administrative accountability question about whether the DOJ has the internal tracking to identify which officials made specific redaction decisions on specific documents. A department processing millions of pages under a congressional mandate should have that tracking. The decisions were made by specific people at specific times. Those people have names. Those decisions left records. Massie was asking whether the accountability architecture of the DOJ could identify those records. Bondi said she had already told him that Wexner's name appeared more than 4,000 times in the files. Massie said, yes, and you listed him as a co-conspirator in one of them, and that was the one you covered up. Then came the 40-minute exchange, and then Bondi's response. 3 documents, 3 documented failures. 1 response. She called him a failed politician, a Republican. 3 documents from her own DOJ. 1 answer. Let's examine what that response does and does not accomplish. The failed politician characterization is a personal attack directed at the person asking the question rather than at the substance of the question. It says nothing about the first document, the email from survivors' lawyers that the DOJ processed and ignored. It says nothing about the second document, the co-conspirator list where Wexner's name appeared under child sex trafficking and was redacted until Massie forced its disclosure in the hearing room. It says nothing about the third document, the FD3 02 forms that layer redaction upon redaction and disappear from the portal entirely. The question was, who in your organization made these decisions? The answer was, failed politician. That deflection is in the permanent record of the House Judiciary Committee next to the 3 documents that produce the questions. A hearing observer can read the question, read the documents, and read the answer. The documents do not change based on Massie's electoral history. The email from survivors' lawyers is the same email regardless of how many elections Massie has won or lost. The co-conspirator list is the same co-conspirator list. The FD302 redactions are the same redactions. Then she called him a hypocrite, citing his vote against a ban on deepfake AI pornography. 2 people voted against it, she said. He was one of them. Massie had not asked about deepfake AI pornography. He had asked about 3 specific documents from the DOJ's own production about the most significant sex trafficking investigation in modern American federal history. The subjects are not related. The deepfake vote may or may not be worth discussing, but it is not an answer to the question of who at the DOJ made the decision to publish survivor names while redacting perpetrator names. When a witness responds to a specific documented accountability question by attacking the questioner's personal record, the response produces 2 things simultaneously. It creates a political conflict that may be reported on, and it leaves the documentary question unanswered in the record, next to the non-answer that replaced it. Massie said this is bigger than Watergate. This goes over 4 administrations. Failed politician, hypocrite. Neither word appears in the Epstein Files Transparency Act. Neither answers the question of who made these decisions. That framing is worth examining. Watergate was a specific political scandal tied to a specific administration. The Epstein file pattern, the progressive accumulation of redactions, deferrals, partial releases, and institutional protection of perpetrator identities across successive administrations of both parties, is, in Massie's characterization, not a single administration's failure. It is a sustained institutional pattern that has outlasted multiple changes in political control. He named them: Obama, Bush, Biden, Trump. Each administration managed some portion of the Epstein file process. Each produced its own version of the same outcome: perpetrators protected, documentation withheld, survivors exposed. Bondi said she agreed that Massie should be asking about Merrick Garland. Massie said, "I don't have to go back to Biden. I can go back further, and you are responsible for this portion of it." That sentence is precise in a way that is worth noting. He was not trying to encompass the entire history. He was not claiming that Bondi created the pattern. The pattern predates her. The Ford administration framing was his acknowledgement of that. But the precision of "you are responsible for this portion of it" means I am not letting the existence of the prior pattern excuse the specific failures that occurred during your tenure. The email from survivors' lawyers existed during her tenure. The Wexner co-conspirator redaction happened during her tenure. The FD302 disappearances happened during her tenure. The prior administration's failures do not retroactively correct those. Bondi's repeated invocations of Merrick Garland as a counter-argument function the same way the failed politician characterization does. They redirect attention away from the specific documents on the screen towards something else. Garland did not process the email from survivors' lawyers that Massie's first document showed. The officials who made the redaction decisions in Bondi's DOJ were serving under Bondi. That is what responsible for this portion of it means. The 17 people who resigned because of the Epstein files are in the record. Massie submitted a document listing them at the end of the hearing through unanimous consent. 17 individuals who had been involved with the Epstein file process and who left their positions. The significance of that number is institutional rather than simply numerical. A single resignation from a sensitive file process can be attributed to individual circumstances: career advancement, personal reasons, unrelated professional decisions. 17 resignations connected to the same file process in a bounded time frame is a documented institutional pattern. 17 people who were working on or adjacent to the Epstein documentation decided to leave rather than continue. The reasons they gave or did not give for those departures are part of what the congressional record should contain. Whether those departures were voluntary, encouraged, or coerced by the institutional dynamics of the file process is a question the resignations themselves raise but do not answer. The document Massie submitted lists them. That list is now in the permanent record of the House Judiciary Committee. Every future inquiry into the Epstein file handling process has access to 17 specific names and the fact of their departure. The nude photographs and identifiable images of survivors that the DOJ published, covered in a New York Times article that Massie also submitted, are in the record. And then there is the letter from Bondi to Kash Patel. Massie submitted it. The letter is from the Attorney General to the FBI Director, and its substance requires examination. Bondi wrote to Patel asking him to stop keeping files from her, not asking him to improve the disclosure process, not asking for a timeline update, asking him to stop withholding files from the Attorney General of the United States, the nation's top law enforcement official, writing to the director of the bureau that reports to her department to say, "You are keeping files from me and I need you to stop." The institutional implications of that letter are significant in two directions. First, it documents that the redaction and withholding process was not fully under Bondi's control, that decisions were being made within the FBI about what to produce and what to withhold that she was not being informed of. Second, it documents that she knew this was happening, that she identified it as a problem, and that she felt it was necessary to communicate the problem in writing. A letter from an AG to an FBI director about withheld files is not a routine administrative communication. It is a documented escalation about a documented breach of the chain of accountability. That letter exists in the congressional record now. It sits alongside the three documents Massie put on the screen. The hearing record on February 12, 2026 contains three documents: a failed politician accusation, a hypocrite accusation, a 17-person resignation list, a New York Times article about nude survivor photographs, and a letter from the Attorney General to the FBI Director about files being kept from her. The Epstein Files Transparency Act required one thing: release the names of perpetrators, protect the names of victims. The DOJ did the opposite. That inversion is documented. The name of the person responsible for this portion of it is also in the record. She's the one who said, failed politician.